how to keep your own music unique, and maybe even know that your song sounded similar to something that you've never heard of before?
Great question. Quick disclaimer, this podcast is great. I hope we're entertaining and fun and get value out of this, whoever's listening. It should not be taken as legal advice or services, though. An actual written agreement, retainer agreements retired for that. And if anyone is interested in working together, we do a free initial consult just to see what's going on, make sure it's the right fit, discuss kind of how billing works and budgets and things like that. So you can always reach out to me, usually email's best. And you can find me at morrismusiclaw.com and also musiclawpro.com. Great question. Yeah, this came up a lot since like the Blurred Lines case a while ago. That was in the news. And then you had Led Zeppelin and you had Katy Perry. So there's a history here, and it's different because if it's just lyrics, it's like, all right, did I use the same lyrics or not? And it gets tricky if it's a short phrase or something. If it's too short, it may not be copyrightable. But when it comes to music, it's like exactly the same. Okay, and but when there's differences, there's only so many notes you can use. There's only so many chords. So it's not an easy, like, bright line. All right, this is 8 bars I can use, or 8 notes, or 2 seconds. Like it depends on every kind of situation. And ultimately there's a balance that happens of creativity on the one side and protecting creators on the other. Like we want to encourage free expression, more music, more creative arts. But we also want to encourage the creation of that to protect the creators so that they're not, being stolen from their original works. So there's a balance that happens, and, it's helpful to look at both sides of that scale, to use the metaphor. It's like, what if I wrote a big hit and then somebody else, copied it or not? Like, would I care or not? And it's nice to look in their shoes. Like, you can get more full-fledged and hire a musicologist to analyze things. You can do easier things like Shazamming it to see if that catches anything of a pre-existing material. Different labels, different companies have different methods or technological tools to help in this regard. And ultimately, if there's a big hit, people come out of the woodworks and try to see what's up. And ultimately, for copyright infringement, hence the name, there has to be a copying. But that copying could be intentional or it could be unintentional. So if you have a big hit and it's just, you don't even know, and then you're writing a song and it ends up being the same melody or too similar, that could be an unintentional copying because you still heard it and you're copying the other side. Whereas if you independently create something, even if it's the same as somebody else, you're fine. Like that's in general okay in this discussion of like whether a song would be infringing or not. But to show independent creation or to show copying, these are details that have to get sorted out in the context of any particular song. And as a creator on the other side of the table, I'll write a song and like usually the first thing is like, did I copy somebody? Man, this is a great song. It must be somebody else. You kind of listen and you hope it's independent. And it's like, wow, that's good. Nobody else has done that. Or, geez, maybe it is too similar to that one. And then, if you get that gut feeling, or if somebody listens, or some of these tools runs it by and it is too close, that's a good time to talk to a lawyer and get some certainty there, as opposed to waiting to see if the potentially infringing work is going to come after you, try to sue you or whatnot. It's important to keep the creativity. We still got to create music and not be stifled in that creativity. And not be afraid that you're going to be sued for copyright infringement. But on the other hand, we want to again respect copyright owners and their works. And there's a lot that goes into this to make sure that we're balancing again. The interests and when it comes to a jury trial, all bets are off. That like the Blurred Lines case, versus the Led Zeppelin case, for example, like just looking at the defendants and how they acted in court, the jury is going to view them very differently, just based on that testimony, regardless of the facts and the actual similarities of the music or not. I get potential clients reach out to me all the time. Somebody has stole my song or infringed it, or the other way around, and we check it out. Send the comparing music, and we will look at it. My staff are all musicians too.
Nice.
And then we work with musicologists, the top in the business. So if it gets to a certain point, then we bring in those experts or negotiate with the other side, and it's fascinating work.
Yeah.
There's it's really, what I don't like is like this uncertainty getting in the way of the creativity. Like we want the music, we want more music, we want to be able to create without worry of just being taken down for copyright infringement. So that, if there are those concerns, it's a good time to bring in a lawyer if you're going to be really serious about, your release. Or if somebody's, if you feel like somebody has infringed your music, it's a good idea to bring in a music lawyer to help understand, your rights and different options moving forward. And sometimes you do a license and you share ownership. Other times you take things down, and other times there's court. If we can't sort it out, that's kind of our last resort of peaceful resolution, is to go to court and work it out there. So it's a fascinating area that we could talk about much more. It's usually helpful to look at in specific context of particular songs, comparing them, and looking at the music and seeing, was enough copyrightable elements copied or not. And oftentimes we can't actually show direct copying. There's not an email that's like, I copied this. It's great if you had that, if you're on one side, but usually it's like you have to actually compare the music. And there's subjective and there's objective tests involved, and it depends on where you are in the country too. There's different tests based on different circuits. They're roughly the same though. And something else that we're usually looking for, if I were to take up a case of copyright infringement like this, is some showing of access, that the other side actually have access to the music. So for example, if it's a big hit, you can kind of show access because it's kind of heard that you heard the hit on the radio or Spotify or somewhere. If it's a smaller song and you can't show that it was actually heard or likely heard, then showing that the files were shared or there's some relationship or some connection can help show that there's access to be able to show the copying. It gets more involved, and again, this is all just kind of general tidbit and not legal advice. But it's important to kind of, for the viewers or listeners, they're like, oh, I got a copyright infringement case, kind of general stuff. So if they reached out to my firm and I didn't get back to them, or there was no case, like just a little bit of why that may be the case, to help kind of illuminate the situation.